Yes, sir. The next witness would fall under the category of chemistry, a forensic chemist. We have someone who has reviewed a good majority of the discovery in this case. The state, by way of an out-of-state witness at the Oak Ridge Laboratories, is attempting to introduce novel science. There's not anyone in the state of Florida that we know of that can assist the defense in analyzing this type of evidence.
You talking about evidence from the body farm?
Actually, no, Your Honor. It's the Oak Ridge Laboratories. It's been misconstrued as being from the body farm. It's a completely separate, different laboratory.
Okay.
But yes, there are, I believe, 2 or 3 from Oak Ridge Laboratory that are going to be testifying. They certainly are listed. They cover different aspects of forensic chemistry. In this situation, we would require 2 experts because, quite frankly, this has never been done, and they don't fall under the expertise of one individual. It's an impossible task to find someone that does this kind of work, and I can actually represent to the court. I've spoken to Dr. Vass, the state's witness, and I asked him, other than yourself, is there anyone else in the country or anyone else anywhere that does this type of work? And he said, well, there's a scientist in Belgium who is doing similar work, but other than that scientist, I don't know who else. So what we've had to do is seek out people who are somewhat familiar with the work, and that clearly requires us to have 2 people. One is located in the state of Florida, and one is not.
Let me hear from the state.
The Oak Ridge Laboratory witnesses consist of an organic chemist, a physicist, and a forensic anthropologist. Those are the fields of specialty that they work in.
So the state has 3 witnesses to cover the area from the Oak Ridge lab.
That is correct, sir. And there, of course, is also chemistry from the FBI laboratory as well. We have a chemist from there as well.
And I take it this scientific evidence involve the use of chemistry and some other fields.
Yes, chemistry, physics in the form of laser examinations, and then forensic anthropology. Dr. Voss is the forensic anthropologist who is the team leader. But all 3 will be involved.
And I take it, Mr. Ashton, from the viewpoint of the state of Florida, this particular evidence has some significance. And if so, what is the significance of this evidence? And what do you hope to establish by this evidence?
This evidence involves a chemical and scientific test which verifies odor observations by humans and a dog, verifying or indicating that the chemical composition of the odors in the trunk of the car are consistent with what has in the past been found in human decomposition.
And I think that's a major component of the state's case.
Before the body was found, it was a huge component. It is still a major component, but less so than it was before. Yes, sir.
I might add to Mr. Ashton's assertions, the FBI chemistry department has also been listed as expert witnesses in this case, where the FBI also has a chemist that the state intends on using.
I believe I said that, yes.
Sorry, I misheard. I thought.
JAC?
We'll defer to the court on this matter. Certainly raise our concern, Your Honor.
One of the aspects of this case, unlike other cases, is a case involving what is commonly known as circumstantial evidence. And because of that nature of the evidence, this makes this case somewhat unusual, somewhat complex, and unfortunately this case besides some of the fact witnesses, you will be dealing with some folks commonly call the battle of the experts. I can understand JAC's concern, but this is not your run-of-the-mill case. Therefore, the court does find that this particular expert is relevant and necessary and will grant the defense's request for those two experts. They are bound by the JAC fee schedule. Your next.
Our next witness would be an expert that would cover under the forensic science of taphonomy.
What? Repeat that.
Taphonomy, Judge. That's the study of human decomposition.
Okay.
A issue that the state will attempt to prove in their case in chief will deal with the timing of the placement of Kaylee Anthony's remains at the recovery site. And taphonomy will play a key role, and as to the study of human decomposition and the rates thereof.
State?
Judge, that's not a recognized specialty. I just don't want us to be bringing in a phrenologist. Tapani, if maybe counsel could spell it for the court reporter.
Taphonomy, T-A-P-H-O-N-O-M-Y. And I'm certain Mr. Ashton can Google it and see that it is a recognized area of forensic science.
T-A-P-H-O-N-Y.
O-N-O-M-Y.
I had to ask too,
Gentlemen, one
Thank you
at
for your help.
gentlemen, one at a time. Are you finished, Mr. Ashton?
Just to say, Your Honor, I think we need more than than the claim that somebody claims Tapani is a real. So forensic anthropologists study human decomposition extensively. They already have a forensic anthropologist. The question would be, what does this Tapani expert add that a forensic anthropologist does not? That is a recognized science. We obviously don't want to pay for someone who is not recognized in science. So,
Judge,
Are you finished, Mr. Ashton?
yes, sir, I am. Thank you.
Okay, Mr. Baez.
I apologize. Your Honor, I can represent to the court that I have sought and labored over many hours to bring the best forensic experts that I possibly can to the defense of Miss Anthony. Taphonomy is a recognized area of forensic science. The background is in forensic anthropology, and the person that will be covering this area does have a background in forensic anthropology. But taphonomy is clearly, and just so to give Your Honor a little bit of the background, several years ago, these body forms.
Let me cut you short.
Sure.
It may or may not be. I can't say at this point. Therefore, as to that particular expert, we will have what is loosely called a Rogers hearing, pursuant to Rogers versus State, 783 7 2nd 980. And it is incumbent on you to establish, I think it's a two-pronged test. So you need to file a motion, set it pretty quickly for hearing. That witness, in order to save costs, can appear by video unless the state has any objections.
Judge, I would have to have some information, but probably not. But I would need some information about the witness before I.
Well, this is what I would tell you. If you're gonna have to utilize the witness to establish, according to Rogers, it will help expedite the matter of the hearing if you provide a curriculum vitae of that particular witness and contact court administration, Mr. Matt Benefield, who's the court administrator, and he can tell you how to make arrangements for that witness to appear by video conferencing to testify, and that can be done easily.
Your Honor, I have no issues with giving Mr. Ashton his CV and taking it from there, cooperating as much as needed.
So we'll do a Rogers hearing on that one. Okay, next one.
Next, Your Honor, would be a cell phone expert. A significant
Cell phone expert.
Yes, Judge. The state has listed, I believe, through MBI, an expert witness that will testify as to Miss Anthony's locations due to cell phone pings, and basically attempt to introduce evidence by way of the cell phone pings to determine Miss Anthony's location at certain points in time, as well as all of her cell phone activity. I think it is an extremely important aspect of the case, quite frankly, because the state doesn't have a time of death. They don't have a location either. And I believe they're going to attempt to use this type of technology to attempt to say Miss Anthony was at said location at said time, and they've gone so far as to try and calculate her sleeping habits by her cell phone activity. And I'm not joking.
How can one calculate when someone's asleep by cell phone activity? They could be wide awake and still not be using the cell phone.
True. However, if they're not on the phone and they're not texting, perhaps they're sleeping. I guess that's their assumption. I don't know.
That's what you call speculation, but
I would agree with you.
Let's hear from the state on this issue.
We do have individuals who are in the telecommunications industry listed as witnesses, some of them with engineering backgrounds, who may testify not perhaps to exactly what Mr. Baez was speculating about, but other aspects of those records, yes.
I take it that those witnesses would be testifying based upon signals of possible locations where the phone would be, since they can't
Correct.
tell who had the phone.
Correct?
And the only thing they can say is that phone was at that location, and that number, I guess, through some type of records would indicate that the phone belonged to Casey Anthony.
Right, that's not really expert testimony on the back half of that proposition, but the front half, yes.
And who do you propose and where their location?
I'm
Mr.
sorry.
Baez?
This person we have not retained yet, and we're looking in state first, and we will go through the proper steps of attempting to find one in state, and then out of state afterwards, if should it be necessary. But I did want to. It's part of the budget, and I wanted a lot for it, which is why I brought it up to the court.
Well, have you taken the deposition of the state's folks?
No, I have not. I can add, Judge, I think.
What I'm trying to determine, Mr. Baez, is whether or not that's necessary, because a phone may have been at that particular location. What value, if any? Remember in Ake versus Oklahoma, you don't necessarily have unfettered access to every expert. And right now I'm struggling with whether or not it is necessary.
I can tell you we have consulted with someone who's out of state and was willing to do it for us pro bono.
Then why not use that person?
I do not know if that person's willing to do it, but certainly I don't think that we would be able to get them to come out of pocket for costs. I'm not there yet, is I guess the representation I can make to the court. But I can tell you that there's a strong likelihood, based on the consultations that I've had, that this is something the defense would need.
Okay. Right now, you have not established that it is relevant and necessary pursuant to Lavender. There is a possibility that you can do that, so that request for that particular expert will be denied without prejudice, so that you can renew it if you can come back and show that it is relevant and necessary. Maybe you can do that after you take the deposition of this person and find out what they're going to testify to, but right now you have not met that threshold. Your next request.
Our next request really deals with, it's not necessarily for a witness, but for costs for some tests that need to be run. The Oak Ridge Laboratory went and purchased 2 vehicles of the same kind that belonged to the Anthony family and ran certain tests in it. We would like to do the same in an attempt to duplicate that. In addition, the state has possession of Miss Anthony's or the Anthony family's car, and I don't anticipate them turning it over to us to allow us to do tests on it. So what's going to be required would be the purchase of 2 Pontiac Sunfires. We estimate that with materials a total of $6,000. Now, I just don't know, particularly since the issues of the novel science, what other alternatives there are to do these types of experiments, but certainly I think it's going to become necessary.
Pursuant to Ake versus Oklahoma in the Lavender case, you have not met your burden to show that that is relevant and necessary. Again, remember the language in Ake and Lavender, that you don't have unfettered access to run every and any test at taxpayers' expense. So that request will be denied without prejudice. If you want to set a Pacific hearing, a Rogers hearing on that, you're free to do it, but at this juncture, you have not satisfied that burden. Next request.
Just for the court's knowledge as well, when I went through this list and I created this list, it was in anticipation for any possible issues that may come up, not the ones that were immediate, and I apologize if I've included those in.
No, you haven't done anything wrong, Mr. Baez. As you said, you're free to ask. You may not get it.
Okay. The other expert that we would be asking for would be that of a jury consultant. I am not aware.
Go ahead.
I am not aware of as to whether the state will be retaining one, but I can. I have a strong suspicion that they will. I think because of this case and its uniqueness, and not just the sheer number of media attention that it's received, but the overwhelming factors, which include those that include community involvement in both the search for Kaylee Marie Anthony, as well as the types of protesters that came out to the Anthony home, and the numerous outrage that the media has portrayed Miss Anthony in the light that they've portrayed her in. I think this is certainly someone that would be essential given the uniqueness of this case, and I know Your Honor has cited multiple times of the uniqueness to this case. I do know that there have been state cases in which court-appointed funds were used for jury consultants, and we would be asking for the same in this case.
Ms. Drain, you have anything you want to say about the state's use of a jury consultant?
Mr. Ashton and Mr. George will be my jury consultants.
Pardon?
Mr. Ashton and Mr. George will be serving as my jury consultants, Your Honor.
Mr. Baez, you have as your co-counsel Mr. Cheney Mason. And Mr. Cheney Mason has been practicing law for more years probably than he would be willing to admit at this stage. He has picked numerous juries, been involved in numerous high-profile cases, and has been, to my understanding, recognized as one of the most preeminent criminal defense attorneys in this nation. And I have presided over at least one first-degree murder trial where Mr. Mason was lead counsel, and Mr. Mason traveled with me to Leon County to pick a jury. Jury consultants, in my estimation, is not a fundamental right under the Due Process Clause either of the United States Constitution nor of the Florida Constitution. The only requirement by law is that in selecting a jury that you have an opportunity to question that juror and that your client be present and that your client has an opportunity to voice whatever opinion your client wants to voice as to whether or not that juror should be retained or excused, whether it's a challenge for cause or whether or not it's a peremptory challenge. Therefore, your request to hire a jury consultant at taxpayers' expense will be denied. Next request.
I just wanted to actually double check and see if that denial was without prejudice, because
It's with prejudice.
okay.
I will not entertain that again.
Our next witness would then be a expert to deal with the canine issues that will arise in this case. As Mr. Ashton pointed out a moment ago, the state will attempt to use evidence dealing with canines, which the defense's position is extremely unreliable, and would like to have the opportunity by way of an expert to show that. And I think there are a handful of issues that may come up in the case dealing with canines, which would also probably include a possible Frye hearing and a motion to suppress specific evidence dealing with the state's attempt to use some of this canine evidence. And based on the multiple issues, we would like to hire an expert to be able to testify to that.
Reply from the state of Florida. Are you utilizing an expert, or are you utilizing a dog handler who testifies as to what the dog was trained to do?
The only individual that we have listed at this point would be actually there are two members of the Orange and Osceola County Sheriff's Office who regularly handle canines. There's no other individual that we anticipate retaining to either supplement or explain any of their testimony at this point.
Mr. Baez, there are legions of cases reported in the Southern Reporter dealing with the use of canine animals to track, sniff human scents and decomposition, to sense and smell explosive devices, drugs. What I'm wrestling with now is this expert that you are asking for. What type of expert it would be, and what would this expert be doing? Is it another dog handler, or just what?
Let me see if I can assist the court in this. The state's dog handler will testify that he conducted an examination of the vehicle. No, it's the state's position that there are signs of human decomposition in the trunk of the car. However, it's a matter and a subject of great debate as to whether that's true or not. I believe the state will attempt to try and introduce, by way of this dog handler, or specifically this canine, that there were signs or scent that this cadaver dog picked up dealing with human decomposition. And I can tell you by personally reviewing this dog's training logs that this dog was both trained on the pseudoscents, which are putrescine and cadaverine, and also the actual scents, which include human bones, teeth, and so forth. In looking at the procedures employed, the highly subjective area of canine, I struggle to even call it science. This will be a significant issue, and there's a great prejudice where I think the state may attempt to do, and based on my diagnosis of some of the discovery and some of the possible testimony in this case, is they may attempt to utilize this evidence as substantive evidence as opposed to or conclusory type evidence, as if it is a conclusion as opposed to a presumptive at best type of analysis, which is what a canine is normally used for. That, in conjunction with the area off Suburban Drive, was also technically cleared by canine units, specifically these two canines. There were searches that involved canine units. There was also an alleged alert given in the backyard of the Anthony home. However, after 3 days of searching, or 2 days, excuse me, of searching, they found absolutely nothing. This will be a very contentious issue, depending on how the state intends on using it. And it's something that is so unreliable, so overreaching with what I believe the attempts are going to be to attempt to use this type of evidence. But I think an expert is essential. Our expert has a doctorate in veterinary medicine. He's an established scientist, and is a very well-known and very well-respected individual in the dog community.